Thank you, Mr. Speaker. Allow me to offer a particularly humble contribution to this debate. And let me state from the outset that the Green Party has not decided its final policy towards this bill and will not do so at this stage of the first reading. We are prepared to vote it through to the Select Committee and listen to the argumentation. That position was not taken lightly, but after some deliberation. The fact is we are sceptical of some of the provisions of the bill and have our reservations on others. But we wish to approach the issue with an open mind and are prepared to explore it with the government and other parties in committee. The bill aims to achieve three things. First, to restore the rank of Queen's Counsel and alter various provisions surrounding the position. Secondly, to alter provisions pertaining to the holding of non-voting shares in an incorporated law firm. And thirdly, to require a power of attorney to be given to another person to conduct the work of the barrister's sole during periods of bankruptcy. It is the first of these aims pertaining to Queen's Counsel that requires exploration. There are three issues at stake. The first is the title of the provision. The second is the potential eligibility for applying. And the third is the method of choosing an applicant. The proposed amendments would reverse three changes made by the Labour government in 2006. In short, this present bill would restore the title of Queen's Counsel, which was dropped by the Labour government in 2006. It would limit eligibility to barrister's sole rather than the general legal profession, which Labour allowed. And it would remove the selection panel and allow the Attorney General to appoint in consultation with the Law Society and the Bar Association. So let us consider each one. Why would the government seek to restore the title of Queen's Counsel? And why would it seek to limit eligibility? The stated reason to revert back to Queen's Counsel is to restore what the government claims is the reciprocal relationship between QC and the Crown. There is an expectation that a QC will sometimes take instructions to act on behalf of the Crown. The qualities which have marked the rank of QC will be preserved. That is to say, the government will continue to have confidence in the rank to appoint QC, to assist with work such as ministerial inquiries where a degree of independence from the executive is thought desirable. The point was advanced by Mr. Power when in opposition back in July 2003. The role of a Queen's Counsel as an independent member of the Bar is to hold an office that allows one to challenge authority. It allows a QC to challenge governments and those who conform to the rules of our society. This is done in a way that gives one a certain degree of independence from such conformity. The fact that the title QC reflects a colonial heritage is, Mr. Power believed, to be of secondary importance. What was more important, he claimed, was that the role of senior counsel would be too readily available to members of the legal profession who practice in large law firms that undertake substantial commercial work for the government, whether it is a department, an SOE or a Crown entity. They act on behalf of the government in those roles. The idea of a QC, Mr. Power believed, was to lift the individual barrister above the mire, so that one is able to take on an unpopular case that others might turn down. A QC is able to hold without fear the views of a client whom all others in a society may view as having committed wrongs, whether civil or criminal. And they would do this well before a judge or jury makes such decisions. Mr. Power urged against removing the last vestige of a barrister's independence at that level, replacing it with a label that could be assigned to any senior lawyer in any firm. There are perhaps some 12,000 or so lawyers in the profession in this country, I think, but only a few hundred barristers sole. This may be a reasonable argument. The aspects of independence and credibility that enables any counsel to take on criminal cases on behalf of a defendant who may be vilified before a trial begins is of critical importance to the integrity of the judicial process. The Green Party has always supported this principle. Yet we remain unconvinced that the very title QC itself is an imperative. We could perhaps accept the argument that the role should be preserved to barristers sole for the reasons outlined. It does not necessarily follow that the title QC itself has to remain. What is the problem with retaining the title senior counsel while restricting it to barristers sole? The third issue has to do with the appointments process. Before 2006, the Attorney-General consulted with the Law Society and the Bar Association over potential candidates. The 06 Act has the Attorney-General being advised by a panel comprising the Solicitor-General and 4 individuals drawn from the New Zealand Law Society and the Bar Association. This 2010 bill would restore the status quo ante on the grounds that the panel system is unnecessarily rigid and it would be preferable for the Attorney-General to have greater flexibility. The difference may not be great between the two arrangements, although a panel's advice might be more appropriate rather than Attorney-General flexibility in itself. It would be useful to consider this argumentation in more detail. Where, for example, is the evidence offered by the government that the panel system is rigid? And what do we mean by flexibility? Reasonable flexibility to some may perhaps be excessive licence to others. As I understand it, there has been only one round of appointments to the position of senior counsel since the 2006 Act came into force. In 2008, 7 individuals were appointed, one of whom was Sir Geoffrey Palmer, and we've heard a lot tonight about Mr Hodder. That is scarcely displaying unacceptable rigidity. On balance, our preliminary thoughts are as follows. First, we would be disposed to retain the title Senior Counsel rather than revert back to Queen's Counsel. Secondly, we are prepared to listen to a more detailed argument from the government to restrict the role to barrister's sole rather than to the legal profession generally. But we do acknowledge the arguments advanced by Labour's David Parker tonight for keeping the potential pool broader than purely QCs. And finally, we tend to favour retention of a panel to accord advice to the Attorney-General in the appointments process. But these are our preliminary thoughts. And based on this preliminary approach, we would consider supporting certain aspects of this bill, but not all of them. We are, however, prepared to see the bill go through to Select Committee with a view to engaging the government in a constructive dialogue on the merits of each of the 3 issues at stake. We shall therefore vote for the bill through to committee while preserving our position to support or oppose the bill in due course.
Mr. Speaker. Ko Rahui.